last year, the New Jersey legislature amended the Fair Housing Act. Amending the Fair Housing Act, they set up a new process for the fourth round, the computation of the obligation, the satisfaction of the obligation. The first step in the process of the Fair Housing Act was for the New Jersey Department of Community Affairs to prepare a report in conjunction with the act and prior court decisions and compute the statewide affordable housing need, break it down into the regions. There's 6 regions, break it down into regions, and then allocate the obligation to each and every municipality within the state of New Jersey. That was done by the DCA, and then the act provides, though, that that number is just advisory to municipalities. It's non-binding. It's just advisory to municipalities, and the municipalities may compute their own obligation. Now, some municipalities in the state of New Jersey just accepted what the DCA did. Other municipalities did make modifications. I think there was a total of approximately 159, around 160 of the municipalities that did make modifications. When you look at the statute, it has 3 relevant factors, and then you average those factors, and then you times it by the regional need, and that comes up with where you get your number. When you look at the non-residential valuation factor, the income capacity factor, nobody changed those. They're kind of numbers. Nobody changed them. Everybody agreed with the DCA's assessment. But when it came to the land capacity factor, the land capacity factor is supposed to be upon developable land. It's supposed to be based upon the region's developable land and each municipality's developable land. But what the DCA is working off of, well, they're in Trenton and they're working off of GIS data, and I think that data was from like 2024. Then they tried to look at some records to determine whether something was still developable or not developable, and they came up with their developable land analysis for the entire state and for each region and for each municipality. So many municipalities, those that challenged it, did focus on that one factor. They took a look and they said, because the statute specifically states that the land capacity factor is supposed to be based upon developable land. It's supposed to be developable. So the Township of Warren in particular looked at those items that were included in the DCA's calculation of developable land, and they made some adjustments for land that wasn't developable. Some of it was open space, deed restricted open space. Well, that's not developable. You can't have that. Some of them were for projects we already have approved for our 3rd round plan, and construction's ongoing on those properties. So that's not developable land. These items need to be removed. So as you know, that calculation was done by our planner, and we came up with an obligation for the municipality of 181 units, and the Township Committee did in fact adopt that, and we filed our declaratory judgment action, all in compliance with the statute. After that was filed, the next step in the process was any objectors. Well, we did receive an objection from the Fair Share Housing Center, and we also received an objection from the Builders Association. What both those objections basically stated was that municipalities, because we weren't the only ones that did, there's 72 municipalities just in our region. We're in Region 3, there's 72 municipalities just in our region, and a number of municipalities in our region did the same thing we did. So it reduces the developable land, and by reducing the developable land, the complete allocation of affordable units that's supposed to be made up for the region gets diminished. So that was the biggest objection of the builders and the biggest objection of Fair Share Housing, saying, if you do this, what you really have to do under the statute is not just reduce your developable land, but then you have to somehow calculate the region. Okay, I don't know how anybody does that, quite frankly. I don't know how any one municipality, you have 72 municipalities, are 72 municipalities supposed to get together and say, what are you doing for your land adjustment? What are you doing for your land adjustment? What changes are you making? We have no idea what the other 71 municipalities are doing as far as their calculations or what was included in their DCA report that they disagree with. There's no way for us to know. So we believe we did it according to the statute, as likewise all the other municipalities that did that, we believe we did it according to the statute. They again though said, hey, we're losing units, and you got to do a regional analysis, and if you don't do the regional analysis, your analysis is no good. That was basically their position. So the first step in the process with the affordable housing program was we were assigned a judge, and we were also assigned, and when I say a judge, these are all retired judges. They're not currently active judges. They're retired judges who are on recall for this particular purpose. And then they would also assign a special adjudicator to each particular municipality, and that special adjudicator is a planner, somebody who does what our planner does. they're planners, so they're familiar with affordable housing. So the first step in the process, we had a settlement conference. The settlement conference was attended by the Fair Share Housing Center. The builders chose not to participate. They indicated, this is our position, that's it, there's no reason for us to participate. So we had a settlement conference with Fair Share Housing Center, and at the first settlement conference with Fair Share Housing Center, unfortunately, because they were involved in so many cases, they just, I guess, didn't have the time to look at the information that we submitted. The information that our planners put a lot of work into. They put a lot of work into saying, we're making these adjustments, here's why we're making the adjustments, and here's our proof. They didn't have time to look at it, so the settlement conference was not fruitful, to say the least. The judge asked them if they could get back to us within a few days with, look at the data and get back to us. Not much happened, didn't hear from them, and what ended up happening was, because there's tight guidelines that this statute had, the way it was written, the program had to immediately schedule us for a session hearing. So we get the session hearing scheduled, we never really had our settlement conference, and the session hearing is supposed to be like, okay, this is not a settled case, let's now put your arguments on the record, and then we'll let you know what our decision is. So what ended up happening was, we go to the session hearing, and the judge at that point in time decided to make it into a settlement conference. So we had a settlement conference, there was discussions that were had, and a proposed number of 225 was floated around. As you guys know, we did, have a special meeting in the Township committee. We did put the resolution before the governing body, and the governing body did decide that they voted against it. And I think the thought process was that we put a lot of work into what we did. We believe that we computed it correctly, and we should continue the challenge. So I notified the judge of that, and he scheduled us for another session hearing, and we did have our hearing in accordance with the statute. We had our hearing, and at that hearing, we put all of our arguments on the record, all the evidence was submitted, and the judge reserved his decision. As you now know, we recently got our decision the other day. It was e-filed, and we got our decision the other day. And what the judge, in a 25-page decision, decided was that he agreed with Fair Share, the argument raised by Fair Share Housing and the Builders Association, saying that you can't just adjust your local need, the entire allocation has to be made, you can't just adjust your local need, it's gotta be done regionally. That's their decision, that's fine. I respectfully disagree, but that is their decision. I would point out to everyone though that now all these decisions are starting to come in, and I've read other ones. So this wasn't the only decision rendered, there was other ones, and there was other program judges. Other program judges agreed with the way the municipalities did it. Did it just like us, and they agreed. They agreed that's the way to do it. That's the way to do it, there's no way, that's the way to do it. So there is a difference of opinion amongst the program judges themselves as to what the statute's gonna require and so forth. Okay, so what is that?
Depending on the judge, different
So we had different
interpretation of the law.
Yeah, there was different outcomes based upon who your who your judge was, who your adjudicator was, and what the decision was. So where does that place us now? Well, this decision now is a recommendation that goes to the Mount Laurel judge, which is Judge Menon, who sits in our vicinage. Judge Vish, he does have the authority to amend it if he wants to. He does have the authority to hold a hearing if he wants to. And he does also have the authority to just check a box and say, hey, you know what, I agree with this decision for the reasons stated, and that's my decision, without a hearing. So those are his options, we'll see what he does. I gotta say, he might just check the box. But I do think there's gonna be inconsistent decisions out there. There's gonna be, if every judge just checks that box, there's gonna be inconsistent decisions out there between, same statute, different interpretations, different results.
And did the same judge give different interpretations to surrounding towns than ours? Or was it just different judges?
It was different judges, but also, in particular, I did notice there was an inconsistency in one of the opinions that I saw from the same judge who adjudicated our case, and it seemed like he reached different results, and the different results were not necessarily based upon the statute, it was more based upon, okay, their adjustments were in as much as Warren's, so I'm kind of like that, so I'm gonna fashion a remedy of how I get to here instead of how I got to here. But it was the same 20-page, the first 20 pages were the same. So that's what ended up happening. At this point in time, there's no worries. I mean, your immunity is safe. This doesn't affect your immunity or whatever. You're still immune from builders remedies lawsuits. We are still in compliance. Nobody's taken our immunity or anything like that. We can still continue our challenge of the number all the way through the appellate division and to the Supreme Court if we want to. But in the meantime, now it's our obligation to come up with a plan, okay? That's the next step in the process, is to plan for our obligation. And that plan, currently, according to the statute, if we don't get any extensions, is gonna be June 30th. So, we do have a committee that has been working on that, and we'll continue to work on that, and we'll continue to update, the Township Committee and the Land Use Board on proceeding forward with that plan to get it in place, by the statutory deadline, so we continue to be immune from builders remedy lawsuits. And that's where we stand at this point in time.
And so, Bill, just to clarify, the next step is a review by memorable judge.
That's correct.
And then subsequent to that, we could appeal to the appellate courts, correct?
Correct.
Got it.
Correct.
Could you speak a little bit more? You mentioned an inconsistency even within our judges' own decisions with neighboring towns, in terms of how his decisions were arrived to, or rather the result of those decisions. In the decision that the judge had given, he had mentioned the need for us to adjust the region's overall numbers. Did he use that same line of reasoning in every other decision that he found?
In any decision where they found in favor of the municipality, no, they didn't, because no municipality did that. No municipality did that. So they didn't find that. They found that that was not required. That was not required. So I think that's a little bit
So not
inconsistent.
required for others, but required for us.
I think that's a little inconsistent.
So we have a situation, just to be clear, that we have other program judges throughout the state reaching different conclusions based on the same law. And we even have within our own program judge inconsistencies in their decision-making process, or at least the decisions that they arrive to based on their own reasoning for those decisions. And to some extent, holding certain municipalities to one standard, saying that they need to adjust the regional number, and then holding other municipalities to a different standard, not even mentioning the requirement to do that because they didn't. Is that a fair summary?
That is a fair assessment, in that there's an inconsistency in that regard, in exactly what you said. Again, no municipality that I know of did recompute the region.
Well, it'd be an impossible task.
Yeah, I think it's an impossible task. The municipalities that did modify their obligation did it exactly like we did.
And so
Did it exactly like we did.
do you feel comfortable, especially given this initial recommendation from this first judge, that we continue to have a case for the number that, mind you, Committeeman Fine, Mayor Lantai, several of our professionals spent a lot of time for, is very evidence-based and robust, that 181 number. Do you feel that that can be defended?
I think there's a basis, sure, under the statute. Again, we have different judges finding differently as far as the statute. I don't know how a municipality, I really don't know how they expect a municipality to, if they're gonna provide and say the DCA number is non-binding, and municipalities can use it to compute their obligation, and then they go ahead and say that the municipality's number is presumptively valid, is computed according to the statute. I don't know how they say, though, that we have to then do the regional, we have to adjust the entire region. I don't know how 72 municipalities and you're gonna get 72 different results. If 72 municipalities do it, you're gonna get 72 different results. It doesn't make sense.
It sounds to me like their decision-making is based not on the research and work that people like Committeeman Fine, Mayor Lantai, and our whole organization put in here, but more based upon the fact that our reduction from the original number was a higher percentage than what some of these other ones were.
I think maybe that had something to do with it. I
Yeah.
do.
They
think
probably
that-
didn't even look at what they did,
I
which
think,
is
I think
very
that,
sad.
I think the percentage reduction had something to do with it, because it seems like the proposed settlement number was around what they were looking for. I think that was, you know, it seems like the proposed settlement number was around what they were looking for. Again, I haven't read them all yet, but I have read a few of them, and, this is what I can update you at this point in time, but again, you do have immunity, that hasn't changed, and we will continue to proceed on both fronts with the obligation, but in the meantime, we do have to continue our plan.
Which is due June 30th.
Yes, ma'am.
And Bill, are there any updates on the, ongoing, lawsuit that we are part of the consortium for?
The updated lawsuit, yeah, recently there was, a meeting and they wanted to go to federal court, to file some equal protection claims. So that's the next step in the process that they're gonna file over there. They also are proceeding, through the appellate division because all those orders did get entered and they weren't successful in the initial rounds before, the trial level judge. So they are gonna proceed with the appellate division. So they're on two fronts. One, they have appellate actions pending, and number two is they wanna file a federal complaint on